In the last video, I highlighted that employment at will is an important benchmark. It's a legal benchmark for which to compare various regulatory regimes. From the perspective of a manager, it's also a functional benchmark in thinking about what you can and cannot do legally. Can you hire whoever you want at whatever terms and conditions you both agree to? But does employment at will exist? On the worker side, can workers work for whoever they want, whenever they want, at whatever compensation they can obtain, and can they quit when they want to? Last time, we saw that the answer to these two questions is yes. What about the organization side? Can organizations hire whoever they want, whenever they want, at whatever compensation and other terms workers will agree to, and can they fire the workers at any time for any reason? Last time, I said the answer to these questions was yes, but with limitations. In other words, there are boundaries around what an organization can and cannot do legally when it comes to the employment relationship. And so let's think of some examples. Can organizations hire whoever they want? Well, anti-discrimination laws say no, at least not in terms of discriminating on the basis of race or certain other specific things. Can organizations hire at whatever compensation and other terms workers will agree to? Well, minimum wage laws, safety regulations, proposals for advance notice of schedules, all say no. What about being able to fire workers at any time for any reason? Well, some countries have unfair dismissal regulations, which again suggests that the answer is no. Organizations cannot fire workers at any time for any reasons. So again, all of these types of restrictions place boundaries around what the organization can and cannot do in the employment relationship. In the legal arena, there are two different types of exceptions to the employment at will doctrine, two different sources of these boundaries around what the organization can and cannot do. There are limitations that come from judicial exceptions to employment at will, which are based on common law interpretations. And there are also exceptions that come through statutes or laws enacted by legislation. So first, let's look at common law. Now, common law might not be a familiar term. It's simply laws based on custom and judicial precedent. So for example, people are probably familiar with property rights. Well, there aren't specific statutes that have been passed granting people property rights. Rather, property rights is a common law right based on custom and judicial precedent, often dating back centuries. In contrast, what we typically think of the law, perhaps, is statutory law, explicit laws like a minimum wage law passed by a legislative body. Okay, so in terms of common law exceptions to employment at will, there's really three different categories that we can quickly look at here. The first category is called the public policy exception to employment at will. This means that it's illegal to modify employment terms, discipline a worker, or fire a worker if doing so would violate another public policy. So for example, if you fire an employee because they refuse your request to lie at a trial, that would violate this public policy exception. If you fire somebody because they've reported fraudulent accounting practices or the illegal use of child labor, that would also be an illegal violation of this. A second exception is the implied contracts exception. If something that you as a manager or an organization says creates a contract with the employee, then making a change to this contract might be an illegal violation of that contract. For example, if you tell your employees that we only dismiss workers after giving them 3 chances to change their behavior, then this might create an implied contract. So you need to be careful what you say. Employee handbooks can also create implied contracts. This is why organizations frequently state that its policies and procedures do not create contractual rights and that they reserve the right to modify policies and procedures at any time. The third and final category of judicial exceptions in the United States is the implied covenant of good faith and fair dealing. Where present, this can prohibit adverse employment actions made in bad faith or motivated by malice. So for example, if an organization fires an older worker to avoid paying retirement benefits, or if an organization fires a salesperson to avoid paying a commission on a sale that that person has already completed, then those would be examples of bad faith dealing, and that would be a violation of the workers' rights. Now, these exceptions vary from state to state. They can be very hard for an employee to prove in a court of law. However, they're good reminders for managers as to how to treat employees fairly. There are also legislative exceptions to the employment at will doctrine. Again, these are explicit laws passed that would restrict how organizations can hire, treat, and discipline and discharge workers. And just like with the common law exceptions, there's a few categories that are useful to look at. First, there are non-discrimination laws. So you can't discriminate against employees on the basis of certain features like race, age in certain cases, sex, union membership preference, things like that. We'll talk about these laws in future videos. Another set of exceptions to employment at will, at least in terms of placing limitations on what organizations can do in terms of the terms and conditions they offer their employees, is that there are laws that provide for certain standards. One clear example is minimum wage laws. You can't pay a wage lower than a minimum wage, even if an employee would agree to it. Overtime premium, scheduling requirements, break times, those would be other statutory limitations, things that an organization has to abide by when setting terms and conditions of employment for employees. And there are also unjust dismissal protections, which we'll talk more about in the next video. These are much more prevalent outside of the United States as opposed to inside the United States. And so again, these laws can be very complicated. They're enacted at many different levels, from the community level to a state, federal, sometimes even international or supranational level, and these are enacted for many different reasons. We'll talk about some of these different laws and some of these different reasons in future videos. Another exception to the employment at will doctrine is that in the United States, almost every union contract requires discipline and discharge be done for good reasons. Just cause is what labor relations professionals calls it. So at least in those cases, that's a big restriction on employment at will. In some states, public sector civil service systems also include just cause protections similar to union contracts. So those would be other sources of limitations on employment at will, limitations on what an organization can't do when dealing with employees. So again, the employment relationship can be seen as a voluntary contractual relationship. Employment at will is an important concept for managers to understand, but it only exists within boundaries. Because the employment relationship involves people, it's a very special relationship. And we'll spend some more time in the next few videos thinking about these boundaries, understanding the importance of these boundaries more carefully.